Hello, everybody. Welcome to the Debt Hotline. Thank you all so much for joining tonight. We have a very special guest, John Skiba, joining, aka the Consumer Warrior. John is a bankruptcy attorney who also runs a YouTube channel, and we're super excited to have him join tonight because our topic is a very common question that we receive at Solo. And we're going to jump into that topic in a moment. But for now, I just want to take a moment to introduce myself. My name is Hannah Locklear. I am a part of Team Solo. At Solo, we help people respond to debt lawsuits and settle their debts before their court date, or even after a court date maybe has happened. We can help people settle their debts for less, save money, and protect their rights. So that's what we do at Solo. I'm coming back from maternity leave. I actually just had a baby in September. So it's been a minute since I've been on the Debt Hotline, but I'm excited to be here again tonight. And like I said, we have a very special guest joining us tonight. I wanted to take a minute to introduce John more. Like I said before, he is an experienced bankruptcy and consumer rights attorney. He is the owner of Arizona Consumer Law Group. Correct me if I'm wrong, John. That's the name of your group.
That's it. Correct.
Perfect. So owner of Arizona Consumer Law Group. So he practices law actively in Arizona and helps represent people through bankruptcy cases. He's helped actually more than 10,000 families who have been struggling with overwhelming debt issues get back on track. So we're really excited to have him here today because he has dealt with a lot of cases. And the topic for today's discussion is I responded to my debt lawsuit, but what happens next? That is a very common question that we get at Solo. People are always wondering, once I've responded and blocked that default judgment, what comes next? And, I think it's very obvious that people would want to know what to expect and maybe feel a little bit anxious and nervous about the future regarding their lawsuit. And so yeah, excited tonight to discuss what you can expect if you have been sued and you've already filed your answer, which is the right thing to do. Definitely always file an answer if you've been sued. But John, do you want to take a moment to just fill in any gaps that I might have missed, and as far as introduction goes?
No, absolutely. First of all, congratulations. Having a baby, that's awesome. So
Thank you so much.
And you're already back at it. So so I think you hit most of it. I run the Arizona Consumer Law Group in Arizona. We do mostly consumer bankruptcy cases, but I really do a lot of, probably half of my practice is defending people who have been sued by creditors. And I kind of got into that. I used to do nothing but bankruptcy, but I found, I had people come into my office. They were getting sued for like $2,500 and saying, hey, I'm going to file a bankruptcy. I'm like, you don't need to file bankruptcy over this. Let's file a response and let's go through this process that we're going to talk about today as a way to resolve it. And so that's the main thing I do each and every day, is try to give people some hope that there's ways to navigate these things. It's not the end of the world, that's not going to jail or anything like that. So, but yeah, that's what I do most of the time. And then you mentioned my Consumer Warrior YouTube channel, where we talk about these kind of things, every day.
Perfect. So I guess high level, John, if you could just share with us, what would you say is a typical thing that a consumer can expect if they've been sued for debt and they've already filed their answer? What are some things that might happen next?
Filing the answer is 95% of people do not do that. And so if you filed the answer, you're ahead of the game already, but that's not the end of the story. And the little asterisk caveat to all of this is it does vary somewhat from jurisdiction to jurisdiction. So depending on which state you're in, there could be some different procedures. Even in Arizona, where I practice, there's a difference between our superior court cases, where it's over $10,000, or justice court, which is under $10,000. So it can vary. But the big picture is, you file your answer, and usually the next step in most jurisdictions is the parties have to do what are called initial disclosures. Essentially, you have to show your cards. Both sides have to show any documents and witnesses and evidence that they have. And so in most states, it's about 30 to 40 days after you file the answer, you're going to get their whole file. People who call my office will say, I just got this giant stack of documents in the mail. After that, the case will likely go to sometimes like a pretrial conference, where the judge will bring the parties in and schedule some dates. You may have to participate in discovery, where they're sending over written requests for information that you have to respond to, and vice versa. You can send it to them. And then eventually it'll get to the point where there's a trial. I often joke that the wheels of justice move slowly in the civil world. A lot of times it takes months, sometimes even more than a year to get a trial date in some states. But almost without exception, too, we can kind of dive into it maybe a little later. But in collection lawsuits, we see motions for summary judgment. Basically, this is a written document that the creditor provides to the court. It says, hey, judge, we don't just take a look at this and tell us if we want to. If you don't, you're going to, the court will just grant judgment. It's more in depth and more. That's kind of big picture what you can expect. Answer, disclosure, discovery, summary judgment, trial. That's kind of what you're looking at overall.
And what would you say, John, in your opinion, is like the ideal outcome of a debt collection lawsuit? John, are you still with us? Looks like we're having some technical issues. For those listening live, thanks so much for your patience while we figure this out.
Oh, hand on my back.
Yes, it looks like we're back. Can you hear us, John?
Yeah, I'm sorry about that. This is one of the few times it's raining in Arizona, so I'm sorry. I think we got some internet issues. My apologies.
No worries. Glad that you're back. I was just saying before you cut out, in your opinion, what would you say is the ideal outcome in a debt collection lawsuit?
Well, I guess it depends on which side you're on. From the consumer, obviously you want dismissal, but I talk to clients a lot. We've got to determine what a win is, because outright dismissal, truthfully, in most cases, it's rare that you're going to actually go to trial and win. Settlement is often the way to go, and because you retain some control over the outcome. If you go to a trial, it's going to be a judge that's going to make a final decision. And so settlement is often a good way to try to resolve it. And, I always say if someone, before you even went to the lawsuit, if you owed $10,000 on a credit card and the creditor came and said, hey, I'll take $22,000 to get this done, you'd probably jump on it and say, done, I'll do it. That saves me $8,000. So I think that's what you have to decide as you're kind of going into this is what is the win? What is it, something that's acceptable? It's not perfect, but at least it'll get it behind you. Because if you do go to a trial or summary judgment, not only, and if you lose, the court's going to not only grant the judgment, but usually attorney's fees, interest, and the whole thing just balloons up and it turns bad. So I think that with most cases, I always say from the consumer's point, my job is to review the evidence and really trying to steer the case into a situation where we can get the best and lowest settlement possible.
Yeah, and I would totally agree with that. At Solo, we've looked at a lot of data from our customers and tried to understand from thousands of interviews kind of what people are seeking for in these types of cases. And most of the time, people just want to be able to settle their case. I think most people who are struggling with debt never plan to get in that position, and so we just try to offer people tools to help them figure out a resolution instead of just running away or even, trying to get a case dismissed when they know that the debt is owed. I think, like you said, settling can be in most cases the ideal outcome. So that being said, we have some questions about navigating this process and potentially how to settle. And we wanted to pick your brain, John, if you don't mind. We had a lot of questions come in about today's topic, and we have a lot of people watching live right now. So For those watching live, if you want to submit your questions in the chat, we'll try to get to as many as possible. But we're going to go ahead and jump into some questions, I think, right off the bat right now. And we had some questions submitted to the Debt Hotline, which is a number that you can call anytime to submit your questions that we typically address once a week. So the number is 801-613-8181. That is the Debt Hotline. So if you ever have questions about debt, you can give that number a call. But that being said, we're going to jump into some real questions now. Let me go ahead and share my screen.
Hi, my question is, I already submitted the answer to the lawsuit. However, they sent me a statement saying if I wanted to settle. I didn't know how to answer that. Can you let me know what's the next step? Because to be honest, it's due to decrease in pay. And I just needed to know in income. I'm sorry. Yeah, I just needed to know what's the best way to do this. Do I go to court? Do I try to settle? Because at $200 a week, it's kind of hard to settle a $6,000 debt. So can you answer that for me? Thank you.
All right, John, what are your thoughts?
Yeah, it's not unusual after you file the answer, you're going to get a letter from the attorney for the creditor wanting to try to settle the case. Part of it, you have to understand, collection law firms, most of them usually have a handful of attorneys, but they're dealing with hundreds, if not thousands of cases. They want to get this thing settled. They don't want to litigate this. And I always say there's no harm in trying to negotiate a settlement. Civil cases, they're governed by the rules of evidence of each state. And the rules of evidence have a rule, it's Rule 408, that says that settlement discussions cannot be used against you. So it's something where you can reach out to them and say, hey, I'll offer X amount of dollars or a payment plan. They can't turn around and say, hey, judge, they offered this. Clearly, they owe the whole thing. They can't do that. So there's no real downside to offering some type of settlement and at least seeing where they're at. I do say this, no matter what you offer, they're likely going to come back with something a little bit higher. So I usually say don't go in with the max amount that you can pay because they're going to counter you when you do it. So, the second part of her question, as far as what do you do if there's not a lot of wiggle room? If there's a lawsuit that's been filed, there are some tools that you can use, and the collectors will often tell you about them. One is what's called a stipulated judgment, or sometimes we call it a pocket judgment, where you can say, okay, there's $5,000 that they're claiming in their lawsuit. I'll agree to pay $3,000. I need 24 months to pay it, no interest, monthly payments, and you're going to sign off on a judgment for the full balance. Basically what that is, that's the kind of insurance policy for the creditor that says, look, we're going to take a lesser amount. We're going to allow you to pay it over time. We're not going to charge you interest as long as you're making those payments. But if you stop making the payments and just kind of blow it off, then we get to take the judgment in full and record it, and we can try to come after you and garnish. So that's one of the ways that's kind of that you can craft something that works for your situation, where monthly payment that's realistic. Because I always say the one thing you don't want to do is agree to something that's not realistic. You don't want to do something and say, look, I'm going to pay you $500 a month. And you're like, there's no way I'm going to be able to pay $500 a month. That'll just turn south on you. But you can come up with something that's realistic. And be okay with walking away and saying, no, we'll just continue to litigate if we can't get a deal in place. But there are some ways you can kind of, tailor it to your specific financial situation to make it, make a lot more sense.
So you mentioned specific ways to tailor it to your financial situation. Can you maybe dive deeper into that?
Yeah, I always say before you even talk settlement at all with the creditor, you need to come up with what I call your settlement budget. You really need to take a hard look at your income, your monthly expenses, and determine, okay, what can I realistically afford without putting, gas, groceries, mortgage, rent, anything else in jeopardy. And that's kind of where you should start from. Now, I always say that the creditor should give you some type of discount if you're agreeing to do this, because you're taking a lot of work off their plate, to be able to, they don't have to litigate it. They don't take it to trial, anything like that. But really, I think you need to start with a real firm grasp of what your budget is, because you don't want to agree, particularly like a stipulated judgment situation. You don't want to agree to that where you're making some payment that turns out to be not realistic. And if you do get into something like that and it's not realistic, I always say communicate with the creditor. Communication, is something I've had situations where I've negotiated a settlement for a client. We come back and some change in circumstance makes it so it's not possible. We reach out quickly, say, hey, look, we've had some change here. Can you work with us on this payment? So I think creating your settlement budget before you really decide to do anything is really the first step of where you need to go to understand what you can afford.
I love that. And it's nice to know that creditors and debt collectors and lawyers will work with you. So it sounds like in this individual's particular situation, if she can just communicate honestly about her situation, there's a good chance that they might be able to budge and accommodate her based on her monthly budget.
Yeah. I mean, there are situations where people are what we call judgment proof, where if your income is Social Security, if you have VA disability, you don't own a home, sometimes I do have clients, people that call my office, I say, sometimes people can do nothing. Those situations are rare, and I don't give that advice a lot. But in general, if there is some type of income coming in, there's got to be, I always say, if they want money and you have some money, there's always got to be a deal that can be reached. You just got to make sure that it's something that you're not putting yourself in a worse situation, and that it's realistic for your, what your reality is.
For sure. Gotcha. All right. Well, let's move on to the next question. And also before we do that, I did want to just add a disclaimer here that although John is a licensed attorney, any of the information we share in tonight's live stream, in tonight's episode of the Debt Hotline, is strictly informational and educational. Please do not take it as specific legal advice for you and your case. It's just strictly educational resources to try to help point people in the right direction. So that being said, here is our next question.
I've got a debt lawsuit from Discover here in Texas. They're claiming I owe around $15,000. What is a good percentage to try to offer to settle? I mean, will they go as low as 30%? What is something to accept? Thank you.
Well, here's how I look at it. Particularly with lawsuits, there's two categories of lawsuits. There's original creditor lawsuits, Discover, American Express, these creditors that don't often sell their debt to third parties. Then there's junk debt buyer lawsuits, portfolio recovery, Midland Funding, LVNB, Resurgent, all those guys. If I'm dealing with an original creditor like Discover, American Express, I always tell clients, hey, you're going to end up paying more. They can demand more, because if they sue you, they're going to have the documents, they're going to have their witnesses, all their ducks are in a row. They're going to win. They know they're going to win. And so you're trying to negotiate more on terms that make sense. If you're able to do a lump sum, $15,000 debt, I would probably start at 40%, knowing that you're probably going to settle somewhere closer to 50 to 70% of that. If you're wanting them to do a long-term payment plan, my experience, you're probably going to be paying something close to the full balance, but you might be able to get a deal with no interest or something like that as you're paying out over time. So yeah, it's a little tougher with original creditors. I mean, Hannah, you guys probably have more experience, obviously, than I do with direct settlement. You guys do that a lot, I know. But original creditors, it's tougher because they're in a better position litigation-wise, and they know it. And so you've got to kind of take that into consideration. That being said, again, my little asterisk to everything, they will look at your personal situation. If you have something that's unique, a hardship that you're dealing with, you got medical issues. I always say, if you're on Social Security, I tell the creditors that every time, because that's a little clue to them. I can't garnish this person. And so there's things like that I do tell, the creditor, look, there's a hardship situation. There's been a death in the family. There's loss in income. There's a divorce, all those kind of things. They do. My experience is I do see creditors will take that into consideration in coming up with some type of resolution to it. So in general, you are going to pay higher for an original creditor as compared to a debt buyer. But make sure to bring up, I tell people, don't give people your tax returns and your bank account and all that, but you can share with them, hey, I've got 6 other lawsuits, in the back here that I'm dealing with. I got a lot of problems right now. What can we do? Can we get a 40% settlement or something like that?
I love that. Yeah, I think the key here is knowing that there is room to negotiate. It doesn't have to be the exact number that's written in your court documents. And we have a tool at Solo called SoloSettle that kind of helps you take the negotiation matters offline or online and make it a digital process instead of having to call or go to court and battle it out face to face, which can be very intimidating. Instead, you can do it all online through SoloSettle. And our tool helps you protect your rights. It helps you use, professional and legal language to, probably increase your chances of getting a good settlement. And if you share some of your financial information, like your income and your monthly expenses, our tool can also help you kind of give you an idea of what would be a good offer to start the negotiations. So it's a really great way to take those negotiations into your own hands and also just get a little bit of help doing it, and I'll do it all online. But yeah, I think that's great advice. And I think there's so many factors that play into the exact amount that you should offer. But just knowing that if you are upfront and honest about your hardships and the reason that you weren't paying your debt off, there is always room to negotiate. So.
Yeah, I agree.
All right, let's go on to the next question.
Hi, my name is Andrew. I had a question. I retained your guys' services to pay off my debt collector, which I did. And I also retained your services to send an answer to the courts. And that was also completed. So the question is what's next as to the results of getting this mark on my credit report removed? What's the process with that? That was pretty much the only question that I had. But I do appreciate everything that you guys have done, and I hope that just solves everything with the creditor and the courts. But yeah, it was pretty easy. It was very helpful that you guys were there during the process. So that was my question. Thanks again.
So it sounds like this individual, Andrew, used Solo to respond to his lawsuit and then negotiate and settle the debt with the SoloSettle tool. And now he's asking, how can I get this delinquent debt removed from my credit report? John, do you have any thoughts on that?
Yeah, well, so some of it, when you're negotiating a settlement, you can ask as part of those negotiations, one of the terms can be that they delete the line of credit. I've had varying degrees of success. A lot of it depends on the creditor, the specific creditor. It depends on whether a debt buyer has purchased it. Often what they say is we will update the credit report to show that it's been settled. And so what you look at, it will show that there's a zero balance and then a notation saying settled for less than amount owed. It does pull it out of active collection status, which that alone can help the credit score. Some creditors will delete it completely. They'll particularly if you're dealing like directly with the original creditor, they have the authority to delete it. I've had creditors push back and they say, hey, look, there's a law called the Fair Credit Reporting Act. This is the law that tells creditors what they have to do as it relates to the credit reporting agencies, the credit bureaus, credit reports. And I always say I have a little bit of sympathies for their argument because it does say they have to report accurately. So the information needs to be accurate. But it also does not require that they report at all. They can delete it. That's an option they have. What I have found is in particularly large creditors, they have internal policies, and sometimes the internal policy is we don't delete. We will update and provide the information. So it may be something, Andrew, if it's already been settled, you've paid it, they've closed it out, as long as they have updated it on the credit report, if it's still there, that's probably as good as you're going to get. And like I said, it does provide some benefit to pull it out of an active collection status. It's not derogatory. It is settled. And then the further you get away from that, the better off you'll be. But that's generally kind of what I see as it comes to credit reporting. Sometimes that's a little bit more difficult. Just to get it to go away is usually unlikely.
But that's nice to know that as a part of the negotiation process, you can require that they remove any negative marks from your credit report and report that the debt was settled. So, okay, awesome. Let's do the next question then.
I was recently sued by Discover for $5,843.42. So I was notified by the state of Indiana that I was being sued by them. With Solo's help, I responded to the lawsuit, and I didn't hear anything for a while from Discover or from the state of Indiana. And then I got a big fat letter from Discover in the mail back in August, and it said that it was a plaintiff's motion for summary judgment that they had filed with the court. Well, I hadn't heard anything from the court, and there was no dates on this or anything as to when I should respond to it or how long I had. So I was waiting to hear from the state. Well, I never heard anything from the state until last month. I get a letter in the mail that says it was an order granting the motion, Discover's Card's motion for summary judgment. So now I don't know what to do now. They moved for summary judgment and it was granted, but I never really had a chance to respond to this. I didn't know what to do because there was no dates or anything. It was just a copy of what they had filed, of what Discover Card had filed. The reason that I didn't really fall behind on payments, we kind of did. We were falling behind because of medical situation. My wife is a bilateral lung transplant, and so we got real behind on the bills because she couldn't work, and it was just me. Fell behind on the bills, and we went and got involved with one of these debt resolution companies, whose name I'll leave out of it, and they told me that no problem, we'll resolve all your debts, stop paying all your credit cards. Well, since then, since I got involved with these people, these debt resolution people, I've been sued twice. The first one, I didn't do anything, and they got a default judgment. That was through Capital One. Well, now Discover sued me. I responded using Solo, and then, like I said, all of a sudden I get this thing that says motion for summary judgment, and they granted it, and now I don't know what to do. What can I do now? What should I do now? What can I do now?
That's a tricky situation. So he's being sued for, I think he said, around $6,000. The reason they stopped paying is because his wife couldn't work because she had some health issues, had a lung transplant, it sounds like. And so they were living off of his income alone. He responded to the lawsuit, and now Discover is filing a motion for summary judgment. You mentioned this motion for summary judgment, John. Can you tell us a little bit more about what to expect if you get that?
Yeah, and it's fairly standard. You're going to get hit with a motion for summary judgment. And it kind of goes back to the fact, like I said, most of these law firms don't have a ton of attorneys be doing trials all day. This is a way they can resolve the case without having to go to court. So the motion for summary judgment, again, it's them saying, hey, judge, we don't need trial. Just look at all of our evidence and tell us if we win. And in most jurisdictions, you have anywhere from 14 to 30 days to respond to it. And it's different than the answer. The answer, you're coming in and saying, basically the court's saying, hey, do we have a dispute here? Do you admit or deny what it is that they're alleging? Summary judgment, they're coming in and saying, there's a dispute, but all the evidence and the law, everything's on our side. So tell us if we win. And so you have to respond to it. And it's more of a substantive response, or you have to attack their arguments, present your defenses. You have to come in and address the legal issues. This is the most difficult part of a lawsuit for people who are representing themselves. It's most often kind of like here, you get tripped up a bit. You're not quite sure what you're supposed to do with it. And this is where, most states, they hold what are called pro se litigants, people representing themselves, to the same standard as lawyers. And it gets tricky because the summary judgment, it's a pretty, heavy document to kind of deal with. So my first bit of kind of instruction would be, if you're going to try to settle, I would do it before you get the motion for summary judgment. They're probably going to send this out 30 to 60 to 90 days after you file your answer. So if you're going to try to get it negotiated, I would try to do that early on, because once they have that file, that gets a little bit more leverage to them in trying to get this resolved. If you're going to try to respond to it, you can do that when you need to do it. If you don't respond to it, the court's just going to grant judgment. But the types of issues you can raise in defense to it is summary judgment should only be granted basically if the parties agree on the underlying facts and they're wanting the judge to apply the law to it and say who wins. So to defeat summary judgment, you have to come in and say, no, we don't agree to the facts. If Discover is the one who's filed it, you've got to come in and say, do you dispute the amount that they're saying is owed? If you're being sued by like a debt buyer, there's the obvious dispute that, the portfolio recovery didn't loan me money. I didn't agree to pay them money. I dispute that I owe this particular entity. So you have to raise those issues and also attack their evidence. It's difficult to do for most consumers. I'm just on your own. It just is. So that's why if you are going to try to negotiate settlement, I would try to do it early on. Once it's granted, judgment's granted. There's no trial, case is over. The only thing you have is appeal rights. In some states like Arizona, sometimes it's as short as 14 days. Most states it's 30 days. If you miss the appeal deadline, it's done. They can then try to collect on it. So you don't get a trial if it gets granted. The case is over at that point for most intents and purposes.
So it sounds like in this situation, once you get to the point of a motion for summary judgment being filed by the plaintiff or the creditor or collector, it might be more tricky if you're representing yourself at that point. But if you try to settle beforehand, maybe before it gets to that point, there's probably a better chance that you'll be able to get a better deal. I don't think it's impossible, though, to settle even after like a summary judgment has been filed. We've even heard of cases that have settled after a judgment has been entered and like very, very late into the case. So it's not impossible to settle at any stage of the lawsuit, but yeah, I think that's really helpful to know, John, that it's best to try to negotiate early on to avoid getting too far into the litigation to where they don't want to work with you anymore.
Yeah. At the end, I've negotiated judgments that are 20 years old. It's something where, again, they want money. If you're offering money, some kind of deal's you can reach some kind of deal. So even if summary judgment's been entered, that doesn't mean that all is lost. It just means that the scales are tipping their way a little more now. And so you may have to pay a little more to get it resolved, just because now they are in a position with a judgment that they can garnish, they can lien property and cause a lot of chaos. So.
Gotcha. All right. Let's go on to the next question then.
Hi, my name is Crystal. I'm in Indiana. I received a summons for a lawsuit or about $1,400 credit card debt. I responded. I submitted an answer in time. They have come back. Their attorneys have come back with a motion for summary judgment. In the answer that I filed, I said, I don't have any knowledge of this debt, yada yada, along that line. And then they responded and basically said, okay, it seems like they're saying, well, we still, here's all our proof, and now we want our judgment, which was, like I said, about $1,400. I'm curious as to what is my next step. I would like to file for an extension for it first, and then also I'm not quite sure what I should exactly do next. I want an extension because the 30 days is kind of a time crunch, but I'm not sure what all I would need to gather next to, I'm trying to avoid garnishment. That's my number one priority. That's my number one priority. So yeah, how can I avoid garnishment? I'm sorry I've gotten a little rambly. I hope I've given enough information for you to kind of maybe point me in the right direction on where to go next. Okay, thank you.
Yeah, if you need more time, I always say reach out to the attorney, because the parties can usually stipulate to extend that deadline. Anytime I'm doing that, I like to come to them with a proposal, say, hey, if it's $1,400, I can pay you $300. Would you be willing to extend the time to respond to this? Which they're trying to get money. They don't want to fight these things. They have limited resources, overworked, too many cases. They want to get this thing settled. And they particularly, $1,400 is $1,400, but in the law firm world, it's probably one of their smaller cases. They don't want to go to trial over this thing. They don't want to put all the work and preparation, because the amount of preparation you have to put in to go to trial over $1,400 is the same as $14,000. So there's quite a bit of work that they have to put into it. So they're probably going to be totally open to extending this out if you're going to offer some type of proposal to get it resolved. So I would reach out to them. If they don't respond, because that's what I hear a lot of times is the consumers will say, hey, I reached out to this law firm. They're not responding. I can't get anybody to respond. You could file a motion to extend the time. I do that. I did one of those last night for that very thing, for motion for summary judgment, just saying, hey, we're trying to work this out. We need a little bit extra time. Give me an extra 3 weeks. So the communication is key. You can request that. And then I would say if you're trying to avoid garnishment, that's when you do need to put some kind of proposal, whether it's a payment plan, whether it's a reduced balance lump sum, get something done like that. And for a $1,400 lawsuit, you'll be able to get something. If you can propose even a minimal payment plan, $500, you're going to get somewhere and probably get it done.
So it sounds like you're pretty hopeful that this person can reach a resolution and settle.
Yeah, no, I think so. You have to be realistic. Like I always say, you're probably looking at 50% settlement, whether we're talking debt buyer or original creditor. But at the end of the day, they don't want to litigate this. Their attorneys don't. They don't want to go to trial. They don't want to have to do all the work that's going to be required to get their judgment. Even a motion for summary judgment, just from an attorney's perspective, even putting together a fairly simple motion for summary judgment is a 3 or 4 hour thing that they're going to have to put together. And, at their hourly rate, they're eating into what exactly anything that they would get out of this case. So you can kind of use that to your benefit of saying, hey, look, instead of continuing to fight this thing, why don't we just settle it? We'll give you $500 and be done with it.
Gotcha. All right. Well, John, I think we've got time for one more question. We have another question that was submitted via voicemail. So I'm going to go ahead and share my screen one more time. I know we got a lot of questions on our live chat, and sorry we weren't able to get to a lot of those. But I do think that a lot of those questions were very similar to the content that we heard from these questions that we listened to. And John, I think your answers addressed a lot of the questions that we received in the live chat. So yeah, we'll go ahead and finish off with this last question then.
I know every court is different on their workload, but about how long before you actually get a hearing date from the time you turn in your answer?
So I think he's asking, how long does it take for you to get a hearing date after you filed an answer?
Yeah, and like you said, this does vary significantly depending on the type of court, what state you're in. Some courts, you file your answer and they immediately set a hearing date where they'll bring you in, and it can be relatively quickly. And usually to me, quickly is 60 to 90 days. Just as an example, in my jurisdiction in Arizona, our justice court system, the time from you filing an answer to trial date is on average 10 months. Superior Court, which deals with cases over $10,000, it's 18 to 24 months. So, it's a long process. Other states may be a lot quicker than that. So like I said, some may be 60 days kind of thing, but it's generally, it's not quick. The rules of civil procedure that govern how civil cases played out, they have very specific things like, okay, you have 20 days or 30 days to file your answer. And then 30 days later, disclosure's due. And then a pretrial conference is going to be 90 days after that. And so you kind of have to go through this system. But you could go, that's something you could even go down to the clerk. The clerk can tell you stuff like that. You can say, on average, how long does it take to get a trial date? And they may be able to say, in our court, it's 8 to 10 months, or they may say it's 2 to 3 months. So it's really going to vary. A lot of it depends on if you're in small claims court, that kind of thing, you're going to get a hearing much quicker. If somebody's suing you for a $30,000 credit card, it's probably going to be quite a bit longer. So, and that could always be short circuited by a motion for summary judgment. So that's the one thing. That's why they like those as well, because the creditor can come in, get the case done much more quickly than if you're actually going to get a trial date.
Yeah, and it sounds like it really does just depend on the state, right? Like I think in California, it can take like a year for your hearing to happen.
Yeah.
So you have plenty of time to negotiate and try to settle before the hearing. But yeah, it really depends on how busy the court is, how backed up the court cases are. And so, yeah. All right. Well, John, any last words of wisdom for anyone watching who has been sued and maybe has already filed their answer or, is right in the middle of the case? Any words of wisdom for someone facing this?
The main thing is just like filing the answer, you're participating in the process. Make sure that check your mail. I guess that's one thing. The courts do everything through the mail. Sometimes people get served with a complaint and summons. And then, we heard one caller say, well, I didn't hear from the court or anything. Almost everything is in the courts is done through the mail system. So check your mail. If there's a hearing date, be there 30 minutes early. Just engage in the process and communicate with the other attorney in their office, and you can get something resolved. The bad things happen when you're not actively participating. If you're not, if they send you a document, don't assume you can just sit there and that nothing's going to happen. Usually there's some type of response that you're going to have to file. So a lot of attorneys will do free consultations on stuff like this, at least kind of point you in the right direction, or sometimes if it's if you're dealing with a lot of money, that's when it is helpful to find an attorney that can help you through that process, or like a legal aid or something like that. But just participating in the process, which most people that, you soloed, they filed an answer. That's the number one thing, but making sure you stay on top of it. So,
yeah, I think the worst thing you can do if you've been sued is, back down and ignore it.
Yeah.
Don't do that. In most cases, the lawyers will work with you, and you can find a resolution. And we at Solo are here to help you through that. So, and if you're in Arizona and considering bankruptcy, John is a great resource as well. I went ahead and shared your website, John. It's skibalaw.com. That's skibalaw.com, skibalaw.com. If you're considering bankruptcy in Arizona, reach out to John, see how he can help you. And, also check out his YouTube channel, Consumer Warrior. John, you have a lot of, resources, educational information on your channel. So we just want to say thank you so much for joining us today to share your expertise in navigating a debt lawsuit and what to expect after filing an answer. I do want to say, if you have been sued, like John said, don't ignore it. Respond to the lawsuit. You can go over to solosuit.com and draft and file your answer. We'll help you file it for you in any state. And then you can use our tool SoloSettle to negotiate with the collectors or the law firm that's suing you and negotiate to settle the debt for less and save thousands. In many cases, if you don't negotiate and don't settle before a judgment is entered, you might end up paying court costs, attorney fees, and post-judgment interest, which can compound over the years. You end up paying thousands more than you originally even owed. So best case scenario could be that you can settle for less than your original amount owed, and cut out all those extra fees and interest. So yeah, Solo can help you do that. John, thank you so much for taking the time tonight to join our live stream and to join us on the Debt Hotline. We really appreciate you. And thanks to everyone who watched. This is the Debt Hotline. Team Solo's here to help. John Skiba, thank you so much. And everybody have a great night.